Small world, the world of informative flashcards. Flashcards in mediation law. Alternative dispute resolution, Part 1. What law is Republic Act No. 9285? When did it take effect? Republic Act No. 9285 is and ACT2 institutionalized the use of an alternative dispute resolution system in the Philippines, and TO established the Office for Alternative Dispute Resolution, and for other purposes. It took effect on April 2, 2004. Republic Act No. 9285 is more popularly known as Section 1. Title: This Act shall be known as the Alternative Dispute Resolution Act of 2004. What is the declaration of policy of the state in enacting Republic Act No. 9285? Section 2. Declaration of Policy. It is hereby declared the policy of the state to actively promote party autonomy in the resolution of disputes, or the freedom of the party to make their own arrangements to resolve their disputes. Towards this end, the state shall encourage and actively promote the use of alternative dispute resolution as an important means to achieve speedy and impartial justice and declog court dockets. As such, the state shall provide means for the use of ADR as an efficient tool and an alternative procedure for the resolution of appropriate cases. Likewise, the state shall enlist active private sector participation in the settlement of disputes through ADR. This act shall be without prejudice to the adoption by the Supreme Court of any ADR system, such as mediation, conciliation, arbitration, or any combination thereof as a means of achieving speedy and efficient means of resolving cases pending before all courts in the Philippines, which shall be governed by such rules as the Supreme Court may approve from time to time. Definition of terms. Section 3. Definition of terms. A. Alternative dispute resolution system means any process or procedure used to resolve a dispute or controversy, other than by adjudication of a presiding judge of a court or an officer of a government agency, as defined in this Act, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini-trial, or any combination thereof. B. ADR provider means institutions or persons accredited as mediator, conciliator, arbitrator, neutral evaluator, or any person exercising similar functions in any alternative dispute resolution system. This is without prejudice to the rights of the parties to choose non-accredited individuals to act as mediator, conciliator, arbitrator, or neutral evaluator of their dispute. Whenever referred to in this Act, the term ADR practitioners shall refer to individuals acting as mediator, conciliator, arbitrator, or neutral evaluator. C. Authenticate means to sign, execute or adopt a symbol, or encrypt a record in whole or in part, intended to identity the authenticating party and to adopt, accept or establish the authenticity of a record or term. Continuation of definition of terms. D. Arbitration means a voluntary dispute resolution process in which one or more arbitrators, appointed in accordance with the agreement of the parties, or rules promulgated pursuant to this Act, resolve a dispute by rendering an award. E. Arbitrator means the person appointed to render an award, alone or with others, in a dispute that is the subject of an arbitration agreement. F. Award means any partial or final decision by an arbitrator in resolving the issue in a controversy. G. Commercial arbitration. An arbitration is commercial if it covers matter arising from all relationships of a commercial nature, whether contractual or not. H. Confidential information means any information relative to the subject of mediation or arbitration, expressly intended by the source not to be disclosed, or obtained under circumstances that would create a reasonable expectation on behalf of the source that the information shall not be disclosed. It shall include 1. Communication, oral or written, made in a dispute resolution proceeding, including any memoranda, notes or work product of the neutral party or non-party participant, as defined in this Act. 2. An oral or written statement made, or which occurs during mediation or for purposes of considering, conducting, participating, initiating, continuing of reconvening mediation or retaining a mediator, and 3. Pleadings, motions, manifestations, witness statements, reports filed or submitted in an arbitration or for expert evaluation. Continuation of definition of terms. I. Convention award means a foreign arbitral award made in a convention state. J. Convention state means a state that is a member of the New York Convention. K. Court as referred to in Article 6 of the Model Law shall mean a regional trial court. L. Court annexed mediation means any mediation process conducted under the auspices of the court, after such court has acquired jurisdiction of the dispute. M. Court-referred mediation means mediation ordered by a court to be conducted in accordance with the agreement of the parties when his action is prematurely commenced in violation of such agreement. N. Early neutral evaluation means an ADR process wherein parties and their lawyers are brought together early in a pretrial phase to present summaries of their cases and receive a non-binding assessment by an experienced, neutral person with expertise in the subject and the substance of the dispute. O. Government agency means any government entity, office or officer, other than a court, that is vested by law with quasi-judicial power to resolve or adjudicate dispute involving the government, its agencies and instrumentalities, or private persons. P. International party shall mean an entity whose place of business is outside the Philippines. It shall not include a domestic subsidiary of such international party or a covenanter in a joint venture with a party which has its place of business in the Philippines. The term foreigner arbitrator shall mean a person who is not a national of the Philippines. Is the provision in E-Commerce Act applicable in mediation proceeding? Section 4. Electronic signatures in Global and E-Commerce Act. The provisions of the Electronic Signatures in Global and E-Commerce Act and its implementing rules and regulations shall apply to proceeding contemplated in this Act. Are the alternative dispute resolution provider and practitioner liable administratively for their acts? Section 5. The ADR providers and practitioners shall have the same civil liability for the acts done in the performance of then duties as that of public officers as provided in Section 38, Chapter 9, Book of the Administrative Code of 1987. Instances where the provisions of this law are not applicable. Section 6. Exception to the application of this Act. The provisions of this Act shall not apply to resolution or settlement of the following: A. Labor disputes. B. The civil status of persons. C. The validity of a marriage. D. Any ground for legal separation. E. The jurisdiction of courts. F. Future legitime. G. Criminal liability, and H. Those which by law cannot be compromised. What is the scope of the provisions of this chapter? Section 7. Scope. The provisions of this chapter shall cover voluntary mediation, whether ad hoc or institutional, other than court-annexed. The term mediation shall include conciliation. In application and interpretation of the provisions of the mediation, what should be considered? Chapter 2, Mediation. Section 8, Application and Interpretation. In applying construing the provisions of this chapter, consideration must be given to the need to promote candor both parties and mediators through confidentiality of the mediation process, the policy of fostering prompt, economical, and amicable resolution of disputes in accordance with the principles of integrity of determination by the parties, and the policy that the decision-making authority in the mediation process rests with the parties. What is the nature of the information obtained in mediation proceeding? Section 9. Confidentiality of information. Information obtained through mediation proceedings shall be subject to the following principles and guidelines. A. Information obtained through mediation shall be privileged and confidential. B. A party, a mediator, or a non-party participant may refuse to disclose, and may prevent any other person from disclosing a mediation communication. C. Confidential information shall not be subject to discovery, and shall be inadmissible if any adversarial proceeding, whether judicial or quasi-judicial, however, evidence or information that is otherwise admissible or subject to discovery does not become inadmissible or protected from discovery solely by reason of its use in a mediation. D. In such an adversarial proceeding, the following persons involved or previously involved in a mediation may not be compelled to disclose confidential information obtained during mediation. The parties to the dispute. 1. The mediator or mediators. 2. The counsel for the parties. 3. The non-party participants. 4. Any persons hired or engaged in connection with the mediation as secretary, stenographer, clerk or assistant, and 5. Any other person who obtains or possesses confidential information by reason of his/her profession. E. The protections of this Act shall continue to apply even if a mediator is found to have failed to act impartially. F. A mediator may not be called to testify to provide information gathered in mediation. A mediator who is wrongfully subpoenaed shall be reimbursed the full cost of his attorney's fees and related expenses. Is the privilege of confidentiality waivable? Section 10. Waiver of confidentiality. A privilege arising from the confidentiality of information may be waived in a record, or orally during a proceeding by the mediator and the mediation parties. A privilege arising from the confidentiality of information may likewise be waived by a non-party participant if the information is provided by such non-party participant. A person who discloses confidential information shall be precluded from asserting the privilege under Section 9 of this chapter to bar disclosure of the rest of the information necessary to a complete understanding of the previously disclosed information. If a person suffers loss or damages in a judicial proceeding against the person who made the disclosure, a person who discloses or makes a representation about a mediation is precluded from asserting the privilege under Section 9, to the extent that the communication prejudices another person in the proceeding and it is necessary for the person prejudiced to respond to the representation of disclosure. Are there exceptions to privilege of confidentiality? Section 11. Exceptions to privilege. A. There is no privilege against disclosure under Section 9 if mediation communication is 1. In an agreement evidenced by a record authenticated by all parties to the agreement. 2. Available to the public or that is made during a session of a mediation which is open, or is required by law to be open, to the public. 3. A threat or statement of a plan to inflict bodily injury or commit a crime of violence. 4. Internationally used to plan a crime, attempt to commit, or commit a crime, or conceal an ongoing crime or criminal activity. 5. Sought or offered to prove or disprove abuse, neglect, abandonment, or exploitation in a proceeding in which a public agency is protecting the interest of an individual protected by law, but this exception does not apply where a child protection matter is referred to mediation by a court or a public agency participates in the child protection mediation. Next page. Continuation. Are there exceptions to privilege of confidentiality? 6. Sought or offered to prove or disprove a claim or complaint of professional misconduct or malpractice filed against mediator in a proceeding, or 7. Sought or offered to prove or disprove a claim of complaint of professional misconduct of malpractice filed against a party, non-party participant, or representative of a party based on conduct occurring during a mediation. B. There is no privilege under Section 9 if a court or administrative agency finds, after a hearing in camera, that the party seeking discovery of the proponent of the evidence has shown that the evidence is not otherwise available, that there is a need for the evidence that substantially outweighs the interest in protecting confidentiality, and the mediation communication is sought or offered in 1. A court proceeding involving a crime or felony, or 2. A proceeding to prove a claim or defense that under the law is sufficient to reform or avoid a liability on a contract arising out of the mediation. C. A mediator may not be compelled to provide evidence of a mediation communication or testify in such proceeding. D. If a mediation communication is not privileged under an exception in subsection A or B, only the portion of the communication necessary for the application of the exception for non-disclosure may be admitted. The admission of particular evidence for the limited purpose of an exception does not render that evidence, or any other mediation communication, admissible for any other purpose. Are there prohibited mediator reports? Section 12. Prohibited mediator reports. A mediator may not make a report, assessment, evaluation, recommendation, finding, or other communication regarding a mediation to a court or agency or other authority that make a ruling on a dispute that is the subject of a mediation, except A. where the mediation occurred or has terminated, or where a settlement was reached. B. As permitted to be disclosed under Section 13 of this chapter. How to avoid conflict of interest on the part of the mediator. Section 13, Mediator's disclosure and conflict of interest. The mediation shall be guided by the following operative principles. A. Before accepting a mediation, an individual who is requested to serve as a mediator shall 1. Make an inquiry that is reasonable under the circumstances to determine whether there are any known facts that a reasonable individual would consider likely to affect the impartiality of the mediator, including a financial or personal interest in the outcome of the mediation and any existing or past relationship with a party or foreseeable participant in the mediation, and 2. Disclosure to the mediation parties any such fact known or learned as soon as is practical before accepting a mediation. B. If a mediation learns any fact described in paragraph A.1 of this section after accepting a mediation, the mediator shall disclose it as soon as practicable. At the request of a mediation party, an individual who is requested to serve as mediator shall disclose his/her qualifications to mediate a dispute. This act does not require that a mediator shall have special qualifications by background or profession unless the special qualifications of a mediator are required in the mediation agreement or by the mediation parties. Can a lawyer participation in mediation? Section 14, Participation in mediation. Except as otherwise provided in this Act, a party may designate a lawyer or any other person to provide assistance in the mediation. A lawyer of this right shall be made in writing by the party waiving it. A waiver of participation or legal representation may be rescinded at any time. Can the parties agree on the place or venue of mediation? Section 15, Place of mediation. The parties are free to agree on the place of mediation. Failing such agreement, the place of mediation shall be any place convenient and appropriate to all parties. What law is the effective agreement to submit dispute to mediation? Section 16, Effective agreement to submit dispute to mediation under institutional rules. An agreement to submit a dispute to mediation by any institution shall include an agreement to be bound by the internal mediation and administrative policies of such institution. Further, an agreement to submit a dispute to mediation under international mediation rule shall be deemed to include an agreement to have such rules govern the mediation of the dispute and for the mediator, the parties, their respective counsel, and non-party participants to abide by such rules. In case of conflict between the institutional mediation rules and the provisions of this Act, the latter shall prevail. Enforcement of mediated settlement agreement. Section 17, Enforcement of mediated settlement agreement. The mediation shall be guided by the following operative principles. A settlement agreement following successful mediation shall be prepared by the parties with the assistance of their respective counsel, if any, and by the mediator. The parties and their respective counsels shall endeavor to make the terms and condition thereof complete and make adequate provisions for the contingency of breach to avoid conflicting interpretations of the agreement. B. The parties and their respective counsels, if any, shall sign the settlement agreement. The mediator shall certify that he/she explained the contents of the settlement agreement to the parties in a language known to them. C. If the parties so desire, they may deposit such settlement agreement with the appropriate clerk of a regional trial court of the place where one of the parties resides. Where there is a need to enforce the settlement agreement, a petition may be filed by any of the parties with the same court, in which case, the court shall proceed summarily to hear the petition, in accordance with such rules of procedure as may be promulgated by the Supreme Court. D. The parties may agree in the settlement agreement that the mediator shall become a sole arbitrator for the dispute and shall treat the settlement agreement as an arbitral award, which shall be subject to enforcement under Republic Act No. 876, otherwise known as the Arbitration Law, notwithstanding the provisions of Executive Order No. 1008 for mediated dispute outside of the CIAC. Referral of dispute to other ADR forms. Chapter 3 Other ADR forms. Section 18 Referral of dispute to other ADR forms. The parties may agree to refer one or more or all issues arising in a dispute or during its pendency to other forms of ADR, such as, but not limited to, a. the evaluation of a third person, or b. a mini-trial, c. mediation arbitration, or a combination thereof. For purposes of this Act, the use of other ADR forms shall be governed by Chapter 2 of this Act except where it is combined with arbitration, in which case it shall likewise be governed by Chapter 5 of this Act. Adoption of the Model Law on International Commercial Arbitration. Chapter 4 International Commercial Arbitration. Section 19 Adoption of the Model Law on International Commercial Arbitration. International commercial arbitration shall be governed by the Model Law on International Commercial Arbitration, the Model Law, adopted by the United Nations Commission on International Trade Law on June 21, 1985, United Nations Document A/40/17, and recommended approved on December 11, 1985, copy of which is hereto attached as Appendix A. Interpretation of Model Law. Section 20 Interpretation of Model Law. In interpreting the Model Law, regard shall be had to its international origin and to the need for uniformity in its interpretation, and resort may be made to the Travaux Preparatory and the report of the Secretary-General of the United Nations Commission on International Trade Law dated March 25, 1985, entitled International Commercial Arbitration, Analytical Commentary on Draft Trade identified by reference number A/CN 9/264. Meaning of commercial for arbitration purposes. Section 21. Commercial arbitration. An arbitration is commercial if it covers matters arising from all relationships of a commercial nature, whether contractual or not. Relationships of a transactions. Any trade transaction for the supply or exchange of goods or services, distribution agreements, construction of works, commercial representation or agency, factoring, leasing, consulting, engineering, licensing, investment, financing, banking, insurance, joint venture and other forms of industrial or business cooperation, carriage of goods or passengers by air, sea, rail or road. Legal representation in international arbitration. Section 22. Legal representation in international arbitration. In international arbitration, conducted in the Philippines, a party may be presented by any person of his choice, provided that such representative, unless admitted to the practice of law in the Philippines, shall not be authorized to appear as counsel in any Philippine court, or any other quasi-judicial body whether or not such appearance is in relation to the arbitration in which he appears. Confidential of arbitration proceedings. Section 23. Confidential of arbitration proceedings. The arbitration proceedings, including the records, evidence, and the arbitral award, shall be considered confidential and shall not be published except 1. With the consent of the parties, or 2. For the limited purpose of disclosing to the court of relevant documents in cases where resort to the court is allowed herein. Provided, however, that the court in which the action or the appeal is pending may issue a protective order to prevent or prohibit disclosure of documents or information containing secret processes, developments, research and other information where it is shown that the applicant shall be materially prejudiced by an authorized disclosure thereof. Court's referral of a case to arbitration. Section 24. Referral to arbitration. A court before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if at least one party so requests, not later that the pretrial conference, or upon the request of both parties, thereafter, refer the parties to arbitration unless it finds that the arbitration agreement is null and void, inoperative or incapable of being performed. Interpretation of the Act. Section 25. Interpretation of the Act. In interpreting the Act, the court shall have due regard to the policy of the law in favor of arbitration. Where action is commenced by or against multiple parties, one or more of whom are parties who are bound by the arbitration agreement, although the civil action may continue as to those who are not bound by such arbitration agreement.